Everybody, this is Vonda Evans with another episode of Law for You. As I promised, I have today with me Marc Deldin of Deldin Law. Now, Marc is very proficient, you got to watch, you can't say expert, in the area of business law. He's a beast. He knows what he's doing, and yes, I said that. He has been very, very successful in many business disputes. And what he agreed to do was come on the show today to talk about common areas that businesses have problems in, and to talk about that so that the viewers would understand, those of you who are businessmen or women, you know, what these common pitfalls are. So, hey Marc, how you doing?
Hi Vonda, how are you?
I'm doing good. Well, tell us a little bit about you and your law firm, and then let's go straight into it.
Three areas primarily. We do business, litigation, and then commercial real estate.
Okay.
There's two attorneys that work in the firm, me and Terry Dennings. Got one support staff. We're located in Grosse Pointe Farms. Most of our work is in Wayne County.
Okay. And so when you say that you're into commercial, what does that entail?
Commercial real estate would be real estate that isn't residential, whether it's an apartment building, retail shop, warehouse, a factory.
Okay, very good. Well, listen, let me say this. I gave everybody a little impromptu preview talking about common areas that people have a lot of problem in. Let's go straight to it. Listen, and I had told everybody, there is what is called an operating agreement. And I guess to better, to break it down, it's kind of like the Constitution. It's the instructions on how and what happens to the business in the event that there's a dispute, in the event that one of the partners dies or they want to sell it. So tell me, what is an operating agreement and why is it important to have a lawyer draft it?
An operating agreement is, they're used in LLCs, and it's an agreement between the partners, which in an LLC they're called members, and it's going to govern the affairs of how the company operates. Why it's important to have a lawyer drafted is not every business, not every set of partners wants the same things.
Okay.
You don't want the same voting power. You might not want the same triggers of what could cause the company to break up.
Okay, and let me just say this. Just say for instance, we're friends and we say, hey, let's do a handshake. Okay, that's not sufficient. But we've been in school together. We went to law school. Come on, nothing comes with. I've been to your wedding. I know your children. Is that a common area that people have business disagreements and they end up in court?
I would say the closer the relationship prior to going in business, the worse the dispute's going to be.
The worse?
The worse.
So wait a minute. I go into business with my cousin. That's going to be bad?
Christmas dinner's not going to be the same if you guys get in a dispute.
Are you serious? So let me ask this question. Give me some common examples of things that the operating agreement may cover, just generally.
So you can restrict the transferability of an interest. If you're going into business with your cousin, you don't want your cousin to sell it to their cousin on the other side that you don't know. You want to be in business with who you're in business with. You can agree upon a price if one party wants out. You can agree upon a threshold for when unanimous consent's required. When can this person spend this? When can the other person
Wait a minute.
object?
So listen, we're in a business together. Can I, as the partner, we're 50-50 owners. I'm getting ready to go to a concert. Can I just go in there and just dip in some cash and just keep it moving? I mean, hey, that's my 50% if I write a note. It governs things like that. Is that correct?
And yes.
Okay. Now let me.
The concert wouldn't be in the best interest of the company.
Okay, very good. So those are things that now our relationship is restricted. It's not the same. It's not, well, you know what, I just took $20 out your purse. Just don't worry about it. It's a lot different now that we're in business together. Is that correct?
Right, and it will spell out what happens if you don't agree. How is that decision made.
Well, let's talk a little bit about that. Now, we can't, talk about different companies because we don't do that. But say, for instance, I don't have all the money. And, look how nice he looks. Hey, I can't afford this guy. Listen, I can't. So I decide I'm going to figure it out. I'm going to Google it or look on the internet, and I'm going to find some help. So I find some help, and maybe, there's some places that I can find that I can fill in the blanks, so to speak. And I put it on my credit card, and I'm like, you know what? That lawyer that was on Law for You, we don't need all of that. It took me less than 20, 30 minutes to do, and it's a fraction of the cost of what a traditional lawyer would charge. What is different about a generic, and we call those generic forms, than something that's more specialized? Can you talk about that?
When you go to a lawyer for an operating agreement, they're going to ask you a lot of hard questions. They may cause you to rethink the handshake structure.
Okay.
So a plain vanilla or a generic operating agreement is going to be just that, and if it's two people and you're 50-50, you're no better than just doing a handshake.
Okay.
The internet's not going to ask you the hard questions.
So when they arise, I need a lawyer. So say, for instance, it says that we can pay, our treasurer a certain amount of money, okay? And that it makes for a treasurer, and then we give a salary. But what if the other partner says, you know what? I don't want the treasurer to have this salary or access to the car, and it's not in there. Does that mean we go to court? If it doesn't spell out all of the requirements, is that something that then if I get angry about, I can go to court? Or how does it trigger it where there may be court intervention?
If you have two people that are 50-50 partners, that's going to require them to agree on everything.
Everything.
If they don't agree, including if they don't agree on issuing payroll on the 15th of the month, the company technically cannot do that. Otherwise, one partner is trampling on the rights of the other partner. So a 50-50 handshake is going to require unanimous consent for every action.
Okay. So who needs an operating agreement? A big corporation, or what kind of business?
See, any business where there's more than one person involved in the ownership or control.
Wait a minute. So me and my best friend, we decide that we're going to open up a donut shop. We would need an operating agreement?
Especially if it's with your best friend.
Why?
If a dispute comes down, you guys want to be able to turn to your operating agreement and see how that dispute's resolved.
So an operating agreement is probably a big, thick document or something like that. It's more than one page, huh?
It's more than one page. They can be long and they can be short. It all depends on what provisions the partners want in there.
Is it common for a person to do a generic operating agreement? The other person is upset about it. They then say, forget it, it's silent, I'm going to court. And there's litigation.
Yes, and it will cost substantially less to spell out how you resolve your disputes before you have them than letting a dispute, than not having that procedure in place, and then you've got, each side has lawyers, and that is not cost efficient.
And normally, when I want to fight over an issue that's not in an in an operating agreement, and the lawyer charges like maybe $5,000 as a retainer, $300 or $400 an hour, that can get very expensive. Is that correct?
Litigation is very expensive.
So how much would, look how fancy it looks, nice Rolex, how much would a standard operating agreement cost around if I came to Deldin Law?
Probably at least around $1,000 to $1,500. The more time that I've got to spend, the more money it's going to cost.
So if I spend $1,500 with you now, it may save me $50,000 if I go to court later on with one of my partners. Is that what you're saying?
Yes, ideally the operating agreement spells out a procedure for resolving any disagreements that hopefully you don't need lawyers for.
Why should partners in an LLC have an operating agreement? Tell us about what an LLC is.
An LLC is a limited liability company that what it does is it insulates the owners from liability for the business debts. If you compare that to the sole proprietorship, which is done through the county by filing a DBA, any debts that the sole proprietor takes on become the debts of the owner. The LLC is it's a shield between your assets and the business's liability.
Wow. So if somebody sues the business, can they come take my house and my car?
Generally, no.
Okay. So that's why an LLC is important to have.
Yes.
Okay. What do you do if you believe that your partner is stealing from your company?
You start planning an exit.
What do you mean?
Well, if you think your partner's stealing from their company, they probably are. They're probably stealing more than what you think. And why would you want to be in business with somebody who's stealing effectively from you?
So an operating agreement would have some provision of how I can get out this company if I found that out?
An operating agreement could spell out a buyout formula.
Okay. And what basically is that?
Buyout formula is if a certain event happens and the partners can agree on which event triggers this, it becomes subject to a buyout formula that either the company or the other partner has to buy out the partner that wants to leave.
Okay, I got this great invention. Listen, it's going to change the world. I don't have a lot of money because I put a lot of money with my patent lawyer, but I just believe it's a great thing. Should I invest in having a lawyer do my operating agreement, my LLC, my corporation, or can I just wait later? What do you suggest?
You can form an LLC and do an operating agreement at any time, but it's better to do it before you achieve a lot of success.
Okay, and why is that?
Success can breed resentments among partners.
Okay.
You want to spell out a dispute before you have your first dispute. You want to spell out the dispute mechanism to resolve that before you have your first dispute. Because if you're having disputes and then you go to a lawyer for an operating agreement, it's going to be very hard.
So kind of it's like this. It's kind of like, in the beginning, we're both happy.
Mm-hmm.
And so it's easier to talk about, if we get a certain amount of money, how we're going to invest it, how we're going to expand the business.
Mm-hmm.
What if one of us gets sick or dies? What if one of us, we just don't like this business? What if we decide that we want to sell our interest to somebody else? It's easier if these people are just beginning, would you say, than if they've been into a business for a long period of time?
Absolutely.
Okay, so you definitely think that it's wise to invest in it. Is that correct?
Mm-hmm.
And if you're going to have a business that you're going to have, just say over $5,000 or $10,000 worth of inventory, it's almost very helpful, if not almost required, that you do have a lawyer do one. Don't you agree?
Absolutely.
Okay, very good. Because why put your money in a product with someone if they become disgruntled and they can kind of railroad your business to the side? Is that correct? Have you seen that?
All the time.
Okay.
All the time.
And as a matter of fact, there's a business court in the courts now for people who have business disputes. Is that correct?
About maybe 7-8 years ago, the legislature passed a law creating business courts in certain counties. The Tri-County area all have business courts, and what they do is they have judges dedicated to handling business disputes.
Okay, I got a big one. I have, I'm not the easiest person in the world to get along with. Believe it or not, it is true. I must admit that. So, I have a disgruntled employee, and I say, listen, this is not working. You got to go. But, I'm going to be professional, and I've looked on the internet, and they said, give somebody, 2 weeks notice. And I do, and I just don't, I avoid that person because I just don't want to deal with them. And then when the 2 weeks comes, I'm like, yes, they're getting ready to go. And then I let them go. A couple months later, I look up, I'm getting served with a lawsuit. It's saying I harassed my employee. Oh my goodness. What am I going to do now? What do you suggest?
First, you never should have given the employee 2 weeks notice.
What do you mean? Why?
An employee gives you 2 week notice. If you give an employee notice, they're going to spend that 2 weeks very disgruntled. Now, you can get rid of them and give them severance pay, but on the way out, you want to do an exit interview.
So wait a minute. So you are saying to me, if I have an employee, it's not good to say, it's not working out, but I'm going to give you some chance to kind of get your stuff together financially. So let's say at the beginning of the month or the beginning of the year, I'm going to let you go. You don't advise against that?
I advise against that. Instead of leaving a bad employee on your payroll and coming to the office, pay them to not be there. If you give them a couple of weeks of severance and then you make them sign a release, releasing the company from any liability.
Why?
Then they can't sue you.
So if I don't do that, then there's a great chance that they could turn around and sue me for maybe harassment or even discrimination because they may be disgruntled. Is that correct?
Yes, and it's documentation, documentation, documentation. If you've got a problem employee, write them up. If there were witnesses to misconduct, have them fill out witness statements and include it in your files.
Well, wait a minute. You talked about an exit interview. What is that?
When you're letting an employee go, you have an interview with them. You go through a set of questions. Have them write out, a statement, how they feel about the company, how they were treated. They don't have to. More times than not, though, they will. And what that does is that is called evidence. Evidence that could be used in a lawsuit against them. Why didn't they say that they felt discriminated against when they were leaving? It was only after they sat at home for a few weeks and they had time on their hands that they came up with this story.
Okay, very good. How can I call you? I mean, this is good, okay? What's your number? I'm sorry.
313-771-5600.
Okay, and so that would be what you would call a paper trail? What's a paper trail, basically?
Paper trail is it's documentary evidence that you create along the path of getting rid of an employee. You don't want to create it after they're gone because
it looks like a cover-up.
Right. If you write somebody up, actually write them up. If you discipline them, write it down. If their supervisor comes to you and complains, have them put in a written statement to you. Now you have this in your file. Now if that supervisor also becomes an ex-employee, he won't be able to change his story to support the other guy.
Wow. How long did it take to learn all of that? That's a lot of strategy.
Takes a while.
So that's why if I come to you, you're going to charge me a little bit more because you have experience in these areas and you're trying to give me information that will make me save money when a person sues me and brings a claim against me. Isn't that correct? To a degree.
Yes, it's always cheaper to go to a lawyer before a problem happens and try to get advice to avoid the problem happening.
Okay, now this is a big deal, okay? How do I prevent my employees from stealing ideas or of opening a competing business down the street after they see how well I do and how I do my business?
So you can have what are called non-compete and non-solicitation agreements that would prohibit your employees from competing against you once they leave their employment.
How?
Michigan courts enforce them. So it's you'd have to sue them to stop them because contracts are made, but they're also breached. So when they're breached, you have to hire a lawyer and you have to go to court. So
here's the situation. Do you do this for a secretary? Do they have to just be a lawyer or something? I mean, that's a tough question. Michigan courts will enforce a non-compete against a low-level employee. However, you've got to be in there as a business and argue that this person's a threat to your competitive interest. The custodian and the secretary aren't. Your managers, people that you've invested time and money into. I trained them. I told them exactly what I need to do. And now, there's a new lawyer and I told them different things on how to interview different things. And, we even talked about maybe even opening up a business that really wasn't along the law lines. Should I have that person maybe to sign that no-compete?
It's not a bad idea to have everybody on a non-compete. Just be judicious in who you choose to enforce it against.
Listen, oh my goodness. I go to a company and I don't like their service. I go on the internet and I leave them a bad review. But I notice when I'm on the internet and I leave them a bad review that there are other people that leave bad reviews. Wait a minute. Not only is my review bad, but there's 6 other people that have bad reviews. I contact them. I say, listen, so you didn't like the services that ABC company performed? No. Well, listen, can we get together and do something about it? Instead of maybe writing a group negative comment, what do many people do?
Many people either find class action.
What's class action? I don't understand what that means.
Class action is when 1, 2, 3, or more people get together and they sue somebody or company on behalf of unknown people that are in a similar situation as themselves.
So what is the benefit of bringing a class action suit? And do people do that when they're disgruntled with companies?
The benefit of a class action suit is hiring a lawyer is expensive. If a company rips you off of $30, you'd be out of your mind to pay a lawyer. But if that same company ripped off 10,000 people out of $30, that's a lot of money. So the benefits of a class action from the plaintiff's perspective, from the plaintiff's lawyer's perspective, is you're aggregating all these claims and you're creating a big pot of money and a big pot of people.
So it may, on the pleading, it may have 1, 2, 3, but they're suing on behalf of 4, 5, 6, 7 that we don't know of.
Correct.
Okay. It's kind of like this. I always get them. You know, you'll get something in the mail and says, if you had a service or a product during a certain period of time, you may be eligible to receive some money back. What's the benefit, however, for the lawyer on the other side or the lawyer that's bringing the action? I'm sorry, what is their benefit from the standpoint of how do they get paid?
They get paid from a common pool of funds. So if there's a settlement or if there's a judgment after a trial, the defendant, the company that got sued, is paying out money.
Wow.
Yeah, and the lawyer's fees are approved by the court, and you get your rebate check for 75 cents, and the lawyers walked away with a nice payday.
So you're saying, wait a minute, hold on for a minute, but the service that I wanted, just say for instance it was a $30, just whatever business it is. So you mean to tell me that the lawyer is going to get more money than me, and I was the one that interest or was aggrieved? How can that be?
That's just the way that's the way the litigation system is. It's not efficient.
So let me ask this question: do lawyers want to do class action lawsuits against businesses that they believe have wronged someone? So there's an incentive for them to do that.
Absolutely.
And what is that incentive?
The incentive is a payday that's more than your hourly rate.
Wow, more than my hourly rate. So if you charge $250, just say, or $300, then if we do a class action or I do one, then that means that lawyer, or if I'm that lawyer, I can charge more than that rate just because it's a class action?
Not because it's a class action, because you're taking a risk. Some class actions, plaintiffs' law firms are putting millions of dollars into those cases with no guarantee of getting paid. So at the end of any class action, a court reviews the hours and the requested fee, and they either approve it or they reject it. There have been some where you get less than your hourly rate, but if you end up returning tens of millions of dollars to thousands of people, and a third of that or 20% of that goes to you, and you've only you have a couple thousand hours, the math may work out where you're making $1,000 an hour.
Wow. So there's incentives for companies that have people who are dissatisfied with their service, they can go to lawyers and do a class action. Listen, what about companies, motor vehicle repair shops? Do they have special exposure to lawsuits? And let's talk about that. You know, when you go to get your car done, now, these places may change your oil and do repairs. These are the ones that we're talking about.
Right.
So do they have a special exposure to the law? And why?
They do. So in Michigan, there's the Motor Vehicle Service and Repair Act. And if that act is violated and the customer suffers damages, they're able to sue and recover twice the amount of damages plus attorney fees.
What?
Yeah.
So wait a minute. I go to a local, a little repair shop, okay? And there's some damage to my car, and I say, listen, you know, as my car is making a noise, and they take off a muffler. They don't give me the muffler, the part back. And I find out later that the part that they said was brand new is not brand new. Do I have a cause of action against them?
Absolutely. And
how?
And that's a crime for the repair facility.
What do you mean a crime?
So at the end of the process, a repair facility gives you an invoice. The invoice says new muffler or new exhaust. But it wasn't new. They just spray painted over the scrape. So they did something. That's fraud, because what they did was they lied to you to get money. So your damages in that case would be the cost of the difference in value from the exhaust that you had and then the new exhaust, probably somewhere in the range of $500 to $1,000. You double that, and the attorney gets paid as well.
Wait a minute. So listen, I have a bad muffler. They don't give me the part back. I find out later that it was not a new part. You mean to tell me that I can then go to a law firm, they'll handle that, and that company has to pay them attorney fees also and double my amount? Wow. Why?
It provides a huge incentive for repair facilities to settle those cases, and oftentimes the customer actually ends up receiving more than what they were damaged, because if one of those cases goes to trial, you're looking at $10,000, $15,000, $20,000 on the plaintiff's side. So the incentive factor is to settle it early. The lawyer's going to get less, but the customer's going to get more.
Okay, so let me ask this question to you. If the muffler was $300 or whatever, and do I have to sue them? Am I limited? Do I have to sue them in small claim court, or can I get a lawyer? How does that work?
You never have to be in small claims court. If you hire a lawyer, lawyers can't practice in small claims court.
Right.
So you can go to small claims court, or you can hire a lawyer.
So basically, to the viewers, the fact that the item that is in dispute is less than $5,000 doesn't mean that you have to go to a small claims by yourself. It means that if you find that this has occurred to you, you can actually call a lawyer to see if they do it, and in that way, that same litigation would be taken out of small claims court. Is that correct?
Correct.
Because that is a company or LLC, normally what they are. Is that correct?
Yes.
And so that doesn't mean that now that I have a lawyer, I have better protection in a situation like that, because I may not be that learned. And so for those people who have had a bad experience at a auto repair store, and they have given you a part that was not brand new, and or they were giving you a part that they didn't return a part, that is actionable. And so so let me ask this question to you. Why do they, and you're saying that the reason that they do is because the law wants to protect the consumer?
The law wants to protect the consumer. When businesses rip people off in a small amount, it doesn't justify hiring an attorney. So there's certain laws that provide for the recovery of attorney fees. Meaning you may have been ripped off $200, but under this law, the defendant who you sue has to pay your attorney fees because it's supposed to provide a disincentive from ripping off consumers.
Okay, wow. So now, and so we can give you a call, and what's the number?
313-771-5600.
Okay, and so we can call you and ask about that.
Yes.
And now let's go back a little bit and talk about, we talked about being able to sue a company. What do I do as a business to protect myself? Why should I hire a lawyer?
You need to be aware of the laws that govern your business. You need to be aware of the Michigan Consumer Protection Act. There's a whole list of acts that the state has deemed to be deceptive. If you violate the Michigan Consumer Protection Act, you could be subject to a class action, you could be subject to an action by the Attorney General, or a single customer could sue you for a very small amount, and the recovery includes attorney fees.
Oh, that's interesting. So I'm a business owner, and I want to be able to avail myself of you and your ability. What should I do? Just give you a call? And how, I can't pay you a lot of money. How should I be able to engage you? What do you suggest the best thing?
Best thing is give me a call. I don't charge you on the first phone call. If I can help you, we'll set up a meeting, we'll talk, and we'll go from there. If I can't, I'm going to tell you that I can't help you.
Mm-hmm. Now, let me ask this question. When we talked about the discrimination, what were those things that you would have indicated again that we need to do to make sure that nobody, if a former employee tries to allege discrimination, what were those things that you suggested before?
Documentation, documentation, documentation. Before they become a former employee, you want to have a personnel file that documents every time they were written up, every time they were disciplined, witness statements if they engaged in misconduct. You want to have evidence to defend against that. Now, if you're terminating them for poor performance, and maybe there wasn't a particular incident, but if you're terminating them, it's always a good idea to at least consider providing them with severance pay, a small severance pay in exchange for signing a release.
And what is severance pay?
Severance pay is pay after they leave in exchange for a release of liability, and then they can't sue you.
Oh, so they can't sue me if there's a severance. Why is that?
Well, if you have a severance agreement, because only a fool would give an employee severance without making them sign a release.
Okay, so basically what this is that this is a person that is signing, they're giving up any claims that they have, but you're giving them money that they haven't really earned.
It's 100% accurate.
Okay, now let me ask this to you. Why would a person want to file, I'm a small company. People always say you should go corporation. What's the difference between an LLC, a sole proprietor, and a corporation from a small business standpoint?
So, from a small business standpoint, a sole proprietorship is always a bad idea.
Why?
Because that's you. That's Vonda out there in the wild conducting business without any shield between you, your house, your car, your savings, and acts that your business does.
So, say for instance, someone slips and falls and they're injured in my business.
Mm-hmm.
At that time, I'm just starting off. I don't have any insurance. If I'm a sole owner, they can actually sue me, and if the damages are insufficient, they can come after my house and my car.
If you're a sole proprietor and you own and operate that building in your name, you are the only one that they can sue.
So it's just not limited to whatever I have in equity or value I have in my business, but they actually can go after me as an individual.
As a sole proprietor, yes.
What about an LLC?
So an LLC is the preferred method of operating a small business. The differences between a corporation and an LLC are a corporation has more formalities. They came out long before states started enacting limited liability company acts. There's a requirement for annual meetings. You should have bylaws and a shareholder agreement.
Well, wait a minute. What's a bylaw? Tell me about that.
Bylaws govern how the company operates. A
Okay.
shareholder agreement governs the rights between the shareholders.
But listen, it's just me and my boy. You know what I'm saying? I mean, we're not that big. Should we still set up, if we're going to do an LLC, should we still make sure, in addition to having the operating agreement that you talked about, should we have any statement about bylaws or how shares would be conducted? But we're only making like $1,000 a week or something. I mean, should we have that at the beginning?
So the answer to that is no and yes.
Okay.
Corporations have bylaws and shareholder agreements. An LLC has an operating agreement, which is basically both of those combined into one. And even if you're not making money in the beginning, that's the best time to spell everything out, because you guys are still boys, you're still best friends.
Okay.
Neither of you have made so much money that you have an outsized ego.
Okay.
And you're more likely to agree on the important provisions when you're both broke or starting out than when the money comes in.
Okay, so those are things that you should do and consider, even though you don't have any shares, even though you don't have any bylaws. I mean, even though you're not that big at that point, you still just want to have them in place.
Yes.
Is that correct?
Yes.
You know what? It's my belief, and I've always said this, that it's better to have it and not need it than to need it and not have it. What about a corporation?
So a corporation is another form of protecting yourself from your business's debts.
Okay.
It's nearly identical to an LLC in terms of the protection that it provides you. It has more formal requirements than an LLC. That's why the modern shift is for people to conduct their business through an LLC.
Now, how much would it cost if I wanted to come to you to form a corporation?
To form a corporation, draft bylaws and a shareholder agreement is probably going to run you around $2,000.
Okay.
So
How much for an LLC?
say around $1,500, give or take, depending on how much time I have to spend in it.
And what about, and does that encompass the operating agreement, or is that something separate?
That encompasses the formation documents, which are called the Articles of Organization. Those get filed with the state, an operating agreement, and then you leave with a tax ID number as well.
So I basically, now you can do this yourself. I mean, really, you can. Is that correct?
You get what you pay for.
You get what you pay for. And there are things that you don't foresee as a layperson that are not spelled out. So a lot of times you have people who, as we've talked about, and I cannot caution people enough to say, listen, if you go into business with a friend or relative, you better get that piece of paper.
Absolutely. You're better off going into business. If you're doing a handshake, do it with a complete
But
stranger.
let me ask a question. If I and my friend, my boy, we own a business, can we have one lawyer, or do we have to have two?
Well, it depends.
In the beginning.
So
If
a
we
lawyer
agree.
can draft an operating agreement with both parties agreeing. So one lawyer is sufficient, but the lawyer shouldn't represent just one of the partners and lead the other partner on that he's also their lawyer. A lawyer needs to disclose, who he's representing, or he can represent both of them if they come to an agreement. He can represent the company in the drafting of the operating agreement, but it's important that the lawyer identify who his client is, so one of the partners isn't under a misunderstanding.
But we both can go to you and we can agree that, we want to pay Deldin Law in order to do the operating agreement.
Absolutely.
Okay, so representation, that's something later on. So we can go in and say, listen, you know what, we've got the building, we've got the logo, we've got the phones, we've got the computers. We got to get the lawyer before we even start that business. Invest that amount of money. Yeah. If you're going to get inventory, if you're going to get a building, if you're going to have vans, etc., you need to make sure that you have that. One last question, I just want to wrap this up a little bit. The LLC, is it important for you to have the LLC if you have transport vehicles? Say just a van or something that drops off. Is that important in case somebody has an accident to make sure that those partners aren't sued?
Absolutely. Whoever's driving it is going to be sued along with the owner of the vehicle. So you want the owner to be, if you're operating a transport company, you want the owner to be your transport company, not you.
Okay. And why is that?
Because if your employee is driving a vehicle that's registered in Vonda's name,
Okay.
Michigan's an owner liability state. If that employee gets in an accident, they're getting sued and Vonda's getting sued.
Wow. So how do I protect against that?
Call me and we form Vonda's Transport LLC.
Okay. And then that way I'm protected, at least my assets, my home, my car, etc.
Yes.
Okay. So listen, you know what? You're not going to believe this. It's almost been an hour. I swear it felt like we just were sitting down. I'm telling you, I can't thank you enough, Mark. It's so important what you just shared, because a lot of people have dreams and aspirations of opening a business.
Mm-hmm.
They don't want to fall into the pitfalls of the legal abyss. And when I say it's an abyss, it's an abyss. And what you want to do is to make sure, and I always say it's better to have it and not need it than to need it and not have it. And the thing that I really like about it is that your rates are reasonable. In that, how much would you charge if you had a person, hypothetically, that didn't have an operating agreement and it was silent as to what I could do or sell my shares, and it was silent about that, or my interest? How much would litigation from the time of filing to the end probably cost at least?
The number of hours I put in times my hourly rate plus costs.
So give me a round number.
It could be on the low end, 10 grand. On the high end, it could run well into the six figures.
So you're saying to me that if you invest in this operating agreement right off, or we go do the LLC with you, that will prevent me in many ways of not being able to expend tens of thousands of dollars and even up to six figures if we're just trying to do it by what we see on the internet, or if it's silent in certain areas.
So it should, because it should spell out what happens in the event of a dispute. And you still may incur legal fees, and partners can breach the operating agreement. So while you could still result in litigation, you've now got a document that where your partner agreed what he was going to do, and then you've got his acts showing that he didn't do that.
Last question. What's a resident agent, and why do I need one if I'm a corporation?
Well, in Michigan, you can't form a corporation or an LLC without appointing a resident agent.
Should it be my mom or my girlfriend or my... Why not?
It should either be one of the partners, a CPA, a lawyer, or there's companies that do it. Is what a resident agent does is they accept service of process for lawsuits and for subpoenas or anything else that requires service of process. They are the designated agent that somebody can deliver document to.
Let me ask you a question. You're out of state. You may be buying houses here. Say, for instance, you make your resident agent your mom. She forgets to tell you, oh, by the way, you did get something from the court. Does that happen when you have people who are not trained as resident agents to take process?
It does happen, and you never want to be in the situation of asking a court to set aside a default judgment.
Because that's what happens. What's a default?
A default is when you get served, when the resident agent is served, you've got either 21 or 28 days to respond. On day 22 or day 29, it's crickets. The other side can file a default, which, if the court enters it, it's basically an admission as to everything that the other side says. You had no voice, you weren't heard, and the court can enter a judgment for what the plaintiff asked for.
But I didn't get it. I mean, when I looked online, it said, it could be a family member or friend. She just forgot.
Well, that's excusable neglect, and excusable neglect is not a reason to set aside a default.
What? So it's better to have a lawyer to be a resident agent or a CPA or somebody like that. Is that what you said?
You want somebody who's covered by a malpractice liability insurance. If your lawyer is your resident agent and he or she does not inform you that you've been sued, that's a big issue for them professionally and with respect to liability.
Okay, very good. And listen, we just want to thank you so much. But again, tell us your location, your number, and everything, so that for our, budding entrepreneurs who want to start their business, who have dreams and aspirations, for those people who are in business, and for those people who are not experienced business problems yet. What's the number that I need to call you at, and how do I contact you?
You can contact me at 313-771-5600. I'm located on Mack Avenue in Grosse Pointe Farms.
Or what about email?
You can email me at marc, M-A-R-C, at deldinlaw, DELDINLAW.com. If you spell Mark with a K, it'll still come to me too.
All right, great. Listen, thank you so very much, and have a great day.
Thank you for having me.
All right.